Welcome to EUPrivacyForAll, Session 19 on GDPR, Right to Erasure and to be Forgotten, Article 17. European Parliament settled in Article 17 a right to erasure, that is to say, to obtain from the controller the erasure of personal data relating to the data subject, and to obtain from third parties the erasure of any links to or copy or replication of those data. These will be retained in the final draft. On the contrary, the paragraph 1a on the application being dependent on the ability of the controller to verify that the person requesting the erasure is a data subject will not be kept. EU Council tackled right to erasure and to be forgotten. It added the obligation to delete data without undue delay, especially in relation to personal data which are collected when the data subject is a child. The data subject shall also, according to EU Council, have the right to obtain from the controller the erasure of personal data if the data have been collected in relation to the offering of information society services to a child. Article 17, finally named Right to Erasure and into brackets Right to be Forgotten, lays down the right to obtain from the controller the erasure of personal data without undue delay, in 6 situations. First, when the data is no longer necessary. Second, when the data subject withdraws consent. Third, when the data subject objects. Fourth, when the data processing is unlawful. Fifth, when the data have to be erased for compliance with legal obligation. And finally, in the frame of offering of information services to a child. The controller shall also take reasonable steps, taking account of available technology and cost of implementation, in order to inform controllers which are processing the data and to which data have been made public by the initial controller, that the data subject has requested the erasure of any links to or copy or replication of personal data. This shall not apply in some cases, that is to say, deletion of data, erasure, would not be feasible in case it would challenge the freedom of expression, it would challenge legal obligation, or any kind of public interest, such as, for instance, in the area of public health, archiving, scientific, historical, or statistical purposes, or, finally, in the frame of the establishment, exercise, or defense of legal claims. Article 17.2a key provision is also laid down in Recital 54 and Article 17b. It really makes central the fact that a controller initially collecting data and transmitting it to additional controllers shall be obliged to inform those additional controllers that the data subject asked for erasure of any links to, copies, or replication of his or her data. Of course, once again, taking into account available technology and the means available to the controller. So, unless this proves impossible or involves disproportionate effort, it is an obligation for the initial controller. Other provisions in GDPR once again stress the fact that member states can decide on national restrictions, specifications and derogations, and that there is basically for the controller an obligation to ensure fair and transparent processing with due care regarding the information of data subjects. Data controllers have the obligation to set time limits in order to ensure that the data are not kept longer than necessary. It also has the obligation to provide modalities in order to facilitate the exercise of their rights by data subjects. Finally, data controllers should be aware of the fact that supervisory authorities have the power to order the rectification, restriction, or erasure of data. In the directive currently, there is no right to be forgotten as such, but there is a right to erasure as provided in Article 12. What should accountable data controllers get prepared for? First, provide data subjects with a right to obtain the erasure of personal data without undue delay. Whenever the data is no longer necessary, data subject withdraws consent, objects, or the processing is unlawful or in the frame of legal obligation, or whenever the data has been collected in the frame of the offering of information, society services to a child. Data controllers shall also ensure fair information of data subjects and set time limits. They should facilitate the exercise of data subjects' rights and take reasonable steps to inform controllers which are processing the data that the data subject requested the erasure of any links to or copy or replication of his or her data, once again taking account of available technology and the cost of implementation. Finally, data controllers should bear in mind that this right shall not apply if processing is necessary to freedom of expression, to a legal obligation, or any kind of public interest. They should also bear in mind that member states can provide restrictions, derogations, or specifications to this right. Finally, the right to erasure, renamed right to be forgotten, and expanded, would be defined by EDPB or court's guidance in order to help data controllers understand what is the scope and what are the limits of this new rewarded right.